today what we would talk about is really the contract and what's involved in the purchase contract and how that's even affecting what's going on with the buyer-broker agreement.
There's a lot of forms, a lot of changes that have happened with the as-is contract. Is really, really advisable to have a realtor working with you on a transaction from the buyer side and the seller side.
An agent posted that they were getting sued from a buyer for not providing comparables. A lot of associations are saying that they don't have frequently asked questions. Can we give them the form and they can fill it out? Can it be hand filled in?
Yeah, on a condominium, there are a few different documents that the seller is required to provide them to the buyer through their agents and through their association. And one of them is the frequently asked questions and answers document. The issue with a title company that either has an attorney on staff or is owned by an attorney is that it's still a title company. So that company cannot legally give any legal advice to anyone because they're not a law firm. The lawyer can give legal advice, but under what umbrella are they doing that? Do they have their own law firm? So a lot of attorneys have their own law firm and then they also have a title company. And I've seen attorneys on closings that they have say, I'm acting as the closing agent on this transaction, not in a legal capacity, but they're also charging a legal fee and they're charging for the closing.
Welcome to Making Money with Laura Sanders, a name you can trust. With over 20 years of real estate experience and selling over 150 homes a year, Laura Sanders is the #1 RE/MAX agent in the state of Florida for 2021. Join us each week as we discuss how to make money through buying and flipping homes to renting versus selling and everything in between. To join the conversation, call in live 888-994-4995, Studio A.
Hi everyone, welcome to Making Money with Laura Sanders, and I am your host, Laura Sanders. Every week we talk about something to help you make a little money, save a little money, or maybe just help you navigate this crazy world that we live in. Today I'm here with an amazing attorney. His name is Charles Esposito. He is with JK Closings, so he can pretty much answer anything you need when it comes down to real estate, but probably not criminal law.
That's right.
So could you advise whether or not you should blow or not blow when it comes to DUI? I'm just wondering.
No, I don't want to give you legal advice on that.
Okay, so that makes sense. I think today what we thought we would talk about is really the contract and what's involved in the purchase contract and how that's even affecting what's going on with the buyer-broker agreement, addendums that are now being added onto the contract, missing addendums. There's a lot involved. I feel like now I have forms coming out my yin-yang.
Yeah, there's a lot of forms, a lot of changes that have happened with the as-is contract, which is the contract that most Florida residential transactions are done on. Now with all of the changes that are coming into place with the National Association of Realtors and the requirements that you guys have, there are more documents than ever that need to be signed. And to our point we were talking about last time, it is really, really advisable to have a realtor working with you on a transaction from the buyer side and the seller side. When you handle things on your own, you make mistakes because they're the professionals.
Well, so it's funny you should say that. Listen, I agree that if they're not comfortable, especially if you don't know if your agent, and an agent can make a mistake even with a lot of experience. I'll give you an example, and this isn't on me, but this was brought to attention to me the other day on a contract. And on the contract, it didn't have when the contract was written, the as-is FAR/BAR contract, which normally you'll see like if it was rewritten in 24.
Yeah.
I think it was like February 20, whatever it was. So in this particular instance, this agent who was buying a property, he was like an investor agent, was buying a property, and he added an additional paragraph into the contract. So if you're like not really paying attention and the contract's kind of going fast, what ends up happening is sometimes you make a mistake. And this particular contract stated that they were going to give 125% of the repairs. They were going to, if they couldn't do that, and if they wanted to back out because they didn't want to do any of this, they had to give like a certain percentage of the deposit amount, which ended up coming out to like another $20,000. It was crazy. And listen, like everybody's busy, and you hope even the attorney you hire doesn't say, oh yeah, this is as is, this is fine. They look at the main points. You actually need to look at it full-heartedly. But what cracks me up the most was a recent deal that I just did, where these younger buyers said, that they were going to have their attorney write their contract, and They didn't want to pay any kind of representation whatsoever. And the loan commitment date came. Do you think I heard from their attorney?
Nope.
Do you think that
You
their
rarely
attorney said, hey, you should, I mean, you would tell somebody, I think you would be different than most attorneys, right? Where I wrote the contract for them and I didn't get paid for that. But my thing is I always feel like I'm trying to do whatever is best for they sent it to the attorney to review.
Yeah, so you're talking about a situation where you were the listing agent and then the buyers came with an attorney?
And they didn't want representation.
Yeah, and you have no obligation to them at that point. And the attorney, maybe the attorney's not really a real estate attorney. You know, there are a lot of attorneys that are, you know, to your point before, criminal defense attorneys, or maybe they're litigators and maybe they're real estate litigators, but a litigator is different than a transactional attorney. A transactional attorney puts deals together and litigators fight. And most sellers and buyers want to buy and sell homes. It's a transactional relationship, and we want the closing to happen. And a lot of litigators just want to fight. So if you're hiring a litigator to do a transaction, odds are you're going to get into a fight over something, but it also might mean that they're not well versed in the particular contract that we use on most of our transactions. You know, so, and the contract, the form contract changes a lot. And to your point about the contract that had all these extra terms in it and everything, they changed the form on that. And if an attorney, you know, wasn't wise to what the forms are supposed to look like and what they're supposed to say on them, they might miss that.
Right.
An agent might miss that.
Oh yeah.
You know,
it taught me a lesson to double check, look again and again. It hasn't happened to me, but I looked at that and I said, you know, that could be easily happen to anybody. Oh
yeah, I have agents send us contracts to review, and they'll say, this contract looks weird. There's something odd about it. And it could be that it's a different form, a different version of the contract. It could be an old version of the contract. I review contracts and I'm looking at them like, when is this from? 2008, it'll say at the bottom. So now they're using a 2008 contract for, you know, 2024, and there's been all of these law changes in between, so the contract doesn't cover all of the different changes. What are you supposed to do? Add 100 addendums to the contract to come into compliance with current laws? It doesn't make any sense. You know, so I actually had to do one for a vacant land contract the other day. It was on a 2010 vacant land contract. And the buyer was actually a large developer, and they took that contract and crossed off tons and tons of things on it to make it their own version of the contract.
Interesting.
And it's very odd, because why do we want to review those contracts and try to figure out what's in them? Why are we not using the most recent version of the contract?
Probably, was it handwritten? Just out of curiosity, was it handwritten?
It was not handwritten, but I have seen a lot of handwritten. And if you do have a contract that has handwriting on it, the handwriting supersedes what's typewritten in the contract.
Really? Okay.
Yeah, because it's a modification.
Okay, so like just an addendum would supersede too, so,
yeah,
which sometimes conflicts the contract, and then you have to go by that.
Yeah, depending on the addendum, you know, because the addendum should be coming later in time, so the addendum that comes later in time should supersede the contract that was originally signed.
Right, and when you're confused about everything that he's saying, you need to call CJ up over at JK. He's got a wonderful staff, he's got a lot of people. We have 4 attorneys on staff.
Yeah, we have 4 attorneys, and we have about 30 employees now, and we have 14 offices throughout the state of Florida, from Miami Beach to Tampa.
That's amazing. That's amazing. So if you're, you know, obviously not sure what you're looking at, and, you know, and you are that silly buyer that wants to just have an attorney look at it. But listen, I don't understand
silly,
why.
I prefer doing real estate transactions when there are realtors involved, because you guys are professionals. So if I have to explain some of the things to a buyer or a seller that are really for industry professionals, they're going to say, well, what do I do? And I may not have the answer to that, because it might be a market related question or a question that has to do with their property. That's not what I'm versed in. I'm versed in the closing, and I'm versed in the contract. You guys are the ones that are versed in the negotiations and the relationship to the property and the market and where it is in the community. We don't have that information.
Right. Not only that, but yeah, you wouldn't be telling them, well, I do think it's worth the value that you're buying it for, right?
Yeah, I don't know anything about individual properties and their value.
I do want to talk about that really quick, actually. It kind of just jogged something in my head. I saw, I'm on this elite group with Remax, and an agent posted that they were getting sued from a buyer for not providing comparables.
That's
Have
interesting.
you heard of that ever?
Listen, this is America. Anyone could sue anyone for anything. Depending on the type of contractual relationship you have with the buyer, you do have certain obligations in a buyer-broker agreement to provide the right services. You also have to come into compliance with the Fair Housing Act, so you know that you can't steer, things like that. For the comparables with a listing agreement, for instance, you're basically agreeing with the seller as to you're going to sell the property for whatever they want, which you come up with a purchase price. And usually the realtors are the ones who come up with those numbers, and you use comparables.
I don't know about that. Most times they come up with it.
A lot of times sellers do have they have an idea of what they want to get, right? If a realtor is not providing the comparables to the seller, not that you're going to get sued for it, but you're opening yourself up to liability because now you can't prove how you got that market value. But it doesn't necessarily mean you have to give comparables to the seller.
It wasn't a listing. It was actually a buyer. Like, it was an agent representing a buyer, and the buyer was suing the agent, saying,
So the buyer sued the agent over comparables. Now, I've never heard of that before. Yeah. And again, you obviously can sue anyone for anything, but if you're looking at a range of houses, usually the buyer has a range of prices that they have for those houses, how many bedrooms they want, do they want a pool, what type of community do they want to live in, the school ratings, all of those different things. So presumably you're looking at those types of properties, so those are comparables. And I mean, I don't know any buyer's agents that don't send kind of a list of the properties that are available.
Right.
So that's interesting.
Yeah. And then I guess, so there's other things that are going on with the contract. For instance, like, a lot of associations are saying that they don't have frequently asked questions. Can we give them the form and they can fill it out? Can it be hand filled in?
Yeah. So the document you're talking about is the frequently asked questions and answers document. And on a condominium, there are a few different documents that are required the seller is required to provide them to the buyer through their agents and through their association. And one of them is the frequently asked questions and answers document. And it has interesting questions on it about the association. What are the rental restrictions? Are they currently engaged in any lawsuits that are greater than $100,000? Things like that. This document is actually outlined in the statute for condominiums, and it states that the condo is supposed to have them available for their members. Yes.
But they've wanted to charge.
They're supposed to be online as well. Now, Florida's updated their condo laws so that all of these documents are supposed to be available on their online portals. So we have a lot of issues with condominium
these are
associations.
some big associations that are not providing it. I mean, big ones.
So the point on this document is, and there are other documents too, but this one is one that the association, I would say about 70% of the associations don't have it, and it has to be updated every year. If the association doesn't have it and the buyer enters into contract with the seller, the buyer actually has the right to void the contract all the way up through the closing date until they receive that document. So it's almost a free way out for the buyer. And so what we normally do is recommend to listing agents, if the association says that they don't have it, we give them the form and the property manager can fill out the form, and now they have the document.
Okay. Now, a lot of times they have refused and said to me, you need to pay for this, $250.
Yeah.
When they say that, how do we fight them back on that?
You can get
This is a really important thing.
You can get an attorney involved. They're not supposed to be charging for things like that. It's supposed to be available online. There are certain things like copies, they can charge a fair rate for copies and things like that, but everything is digital now. And there are laws that have been passed in Florida for condominiums to have their documents online. And if they're not in compliance with the law. So
they need to have their condo docs online too?
Yeah, between me and the condo association attorney that we generally refer to when there is an issue with an association, we're usually able to get what we need out of an association. But sometimes they're very, very difficult.
Even with an attorney, that's crazy.
Oh yeah.
But I was actually talking to an attorney, actually somebody that you bought your company from.
Oh, yes.
And we were talking, and he said to me, because he became a realtor, and he said to me, he said, it's amazing when you're an attorney, the difference, the responses versus being a realtor.
Yeah, good and bad. Good and bad. So a lot of agents and buyers and sellers don't want to work with attorneys. We were talking before about litigators. They tend to make the process, the transaction, they gum it up, they slow it down, they want to fight. We're closing attorneys. We want to close. We generally represent transactions, although we do represent buyers and sellers too. The goal is usually to close. Some attorneys, the goal is to fight. But when you're an attorney and you're asking for something versus a realtor or a buyer or a seller, it's a double-edged sword. We might be able to get what we want because people are intimidated that an attorney is speaking with them, or people might clam up and say, oh no, I got to get my attorney involved, especially associations. So we generally like to stay in the background until we're absolutely needed because we don't want to intimidate somebody into screwing up the transaction, really.
Right.
You know, everybody generally wants to play nice until we can't play nice anymore.
Well, we're going to go to commercial break, and when we come back, we're going to continue to talk about the contract and other things that you need to be looking out for. So stay tuned. We'll be right back.
Whether you're buying, selling, refinancing, or building your dream home, you have a lot riding on your loan specialist. Max Fish, a top 1% mortgage loan officer in the nation, will give you a same-day qualifying quote. Max Fish is committed to providing his customers with mortgage services that exceed their expectations. Ensuring that you make the right choice for you and your family is his ultimate goal. Contact Max Fish today at 954-729-6933 or max.fisch@nwmcorp.net.
At JK Closing Attorneys, we do all of the same things that a title company does, but with the benefits of being a law office. We can help with residential real estate, short sales, commercial real estate, refinances, 1031 exchanges, and FRIPTA withholding.
Contact JK Closing Attorneys today at 954-332-3111. Again, that is 954-332-3111.
You have been watching Making Money with Laura. For more information, contact Laura Sanders at 954-650-0827 or visit her website at thelorasell.com. And now back to the show.
Hi, everyone. Welcome back to Making Money with Laura Sanders, and I am your host, Laura Sanders. I am here with Charles Esposito with JK Closings, and we're talking about the purchase contract, which, number one, correct me if I'm wrong, you're saying you should use a realtor, and you should be, obviously, you should be using a title company that's run by.
Well, we're a real estate
attorneys.
law firm, so in Florida you can close with a title company or a law firm.
But you're recommending to have lawyers on staff.
Yeah, if you don't have a lawyer available to you and you have legal questions, who's going to answer those questions?
Right. Yeah, because I would imagine if I, as a realtor, cannot, and people they're mind blown when I say I can't interpret the contract. They're like, you wrote it. I go, I understand that, but I can't interpret it.
Yeah, that's correct. You would be practicing law without a license.
Right. Only on TV am I a lawyer.
Yeah, exactly.
And then,
I've had agents get sued for that before, too.
Really?
Yeah. So I had an agent one time that told a buyer that was canceling during their loan approval period that they were going to receive their deposit back. Okay, which, if you understand the contract, there are ways that you could lose your deposit because you could be in default. So the agent, rather than having an attorney explain how the contract works to the client, they just told the client, yeah, we'll cancel the contract and you'll get your deposit back. The problem is the sellers requested the denial letter from the buyer's lender, and the buyer's agent sent the denial letter over to the sellers, and then the seller's attorney said, oh, we're claiming the deposit, the buyer's in default. The denial letter said that they were being denied in part because they didn't timely furnish all documents to the lender, and specifically in the contract it states that that's a default. And so the buyer's agent is not required to send a denial letter over to the seller side. They sent it over, and then they ended up going to mediation. They ended up not settling in mediation. It went into litigation, and then the buyer ended up losing. They ended up having to pay attorney's fees to the seller, and they lost their deposit, and they ended up suing their broker. And the broker, their insurance didn't actually cover it because they said they were practicing law without a license. Because they interpreted the contract and said the contract
having
means
insurance?
this.
But that's the purpose of having
But
this
the
is
agent was acting
mind-blowing.
outside of the scope of their responsibilities, and your insurance only covers you for what your job is. It doesn't cover you for acting as an attorney. My job.
But okay.
Yeah,
So
that's
let's
a scary
just say,
one.
though,
That doesn't happen very often, and agents are not.
But what if the listing
usually liable
agent
for very
says,
many things.
send me the denial, right? You send the denial, and you ask the buyer,
But
is it
why
okay
would
if
you
I
send
send
the
it?
denial?
Because they want to know, like, that you're denied.
Yeah, but you don't have to be denied.
So
could just-
so when you're in loan
so
approval
in the
period,
contract, it's the loan approval period.
so you
It
can
doesn't
say,
say loan denial in the contract anywhere. It doesn't state that the loan denial letter is one of those things you have to provide to the seller at all. You have to give status updates on your loan approval. So for instance, let's say you go 25 days into a contract and you're not approved yet, and your lender is working on it. They need something from the association, they need something from the IRS, whatever they need. Are you denied?
no.
But you're not
able.
approved.
But you're not able to make it in that time frame.
Right. You can't get loan approval during the time frame in the contract.
So what happens if a
what are you
seller?
gonna send them?
So what do you do in the case where you send the denial letter? Not that I'm sorry. You tell the agent, the listing agent, hey, we're not able to make loan approval.
Yeah.
We're going to either need an extension or we're going to need to
Yeah.
cancel.
That
And then the
con-
seller says, no, I'm not signing it.
Yeah, that conversation,
Happens
you
a lot.
you don't need a seller to sign a
Release?
well, you need them to sign a release in order to release the escrow. You don't need them to sign a cancellation. The buyer has the right to cancel, and then if the seller thinks they're in default, they can ask for more information. Generally, how the conversation goes is the buyer does not have loan approval, and then the seller says, well, I want this and I want that. And then the next answer should be, well, the buyer's not obligated to send you any of those things. They don't have loan approval. So now, usually, if it's an attorney, the attorney will get on board and agree that that's what the contract says, and I can talk back and forth with the seller's attorney. If it's a listing agent that I'm dealing with, then I might have to have the conversation with them. Thank you for your legal opinion, but if you'd like to have the seller's attorney contact me about what the contract says, then let's do that. And usually we get the seller to sign a release and cancellation. The contract doesn't require a release and cancellation to be signed. It's escrow agents that want a release and cancellation because nobody wants to release money from their escrow account without authorization from both parties. So if your buyer just says, oh, I'm canceling the contract, and I take that as the gospel and give them their money back, they might be in default, and I don't know that because I have no idea whether or not they breached the contract in some way by maybe not giving all the documents to the lender that they were supposed to.
So if you go to a title company that's not, and of course the title companies are going to say, oh, well, we have a lawyer, like if we need to ask questions.
There are a
but-
lot, and there are some good ones that have great attorneys, you know.
Right.
Yeah, there are some. I can't think
But
of
I
any off
mean,
the top
how
of my head.
often are they really? But a lot of times, like there's one title company specifically that if you have an issue, they have an attorney, but you're not to ask them any questions, nor will they help you.
Yeah, so the issue with a title company that either has an attorney on staff or is owned by an attorney is that it's still a title company. So that company cannot legally give any legal advice to anyone because they're not a law firm. The lawyer can give legal advice, but under what umbrella are they doing that? Do they have their own law firm? So a lot of attorneys have their own law firm, and then they also have a title company. And I've seen attorneys on closings that they have say, I'm acting as the closing agent on this transaction, not in a legal capacity, but they're also charging a legal fee and they're charging for the closing. So that's an interesting thing that I've seen on a couple of transactions. We're a law firm, so we are always a law firm. We do closings through the law firm. We don't have a separate title company, so I never take off my attorney hat. It doesn't necessarily mean that I'm representing a seller or a buyer. I could be representing the transaction, but I never have to worry about whether or not I can give legal advice or interpret the contract or anything
Well,
like
yeah,
that.
but that's because you're a lawyer too, right?
A lot of title companies too that have attorneys on staff, the attorney may not be the owner of that company. If the title company is owned by somebody other than the attorney has pressure from the ownership group to close transactions or to mitigate risk, or so they may be uncomfortable giving advice that would actually be harmful
Because
to
it
the
would
company.
also be construed as representation.
Yeah, so for instance, if a seller wants to get out of a contract and I represent the seller, I can certainly tell them how to get out of that contract because I represent them. If the title company is the closing agent on the transaction and one of the parties wants to cancel the deal, well, that doesn't help the transaction. So why would the title company help that client actually cancel the transaction? So
I tell that to people all the time. Yeah, they're not.
Closing
especially
agents
for a
have to be
seller.
very, very careful about what they tell realtors and clients because they don't represent the clients themselves.
And you know what's funny? So it's funny, actually, you guys represented a seller for me recently, and a whole bunch of like crazy things came up, right? And of course, the sellers were like, oh, why do we need that? We don't need that. We want to just go to the, and I go, you don't understand. They're not there for you. They were not picked by me. I don't know anything about them. And in the end, if there's a problem, now you need somebody to interpret the contract.
Right. So the closing
$850
agent-
right off the bat just to get an attorney to like represent you. Why would you want to step in when they didn't want you to represent them from the beginning?
Right.
Like, so it's like I tell them, I'm like, it's better to just be in that position so that when it happens, they're already involved.
Right.
Why would you want to bring them in afterwards?
If we're representing a seller on a transaction and the buyer's chosen the closing agent, we have all of the information that has happened on the file already. If the seller waits for representation until the day of closing and the buyer can't close, now we have to play catch up. We have to learn everything about the transaction
And that costs time and
figure
money.
out. Yeah, we don't know whether or not the buyer's actually in default. We don't know any of the details. We have to get up to speed in a quick amount of time as well.
Yeah.
And, so it's much better for us to be involved from the beginning of the transaction.
Right.
And I always say before the transaction, I want to review the contract ahead of time because I can prevent issues from occurring that I see in contracts all the time. To your point where we talked about the contract that was on the incorrect form and it had more information in it.
Yeah.
That's something that could have prevented a problem and prevented a dispute if it
Sounds
was
like this
reviewed
person's
ahead of
going
time.
around doing it all the time.
Yeah, oh yeah. And I've seen there's all sorts of contracts out there. There are attorneys that have their own contracts. There are also these subject to contracts that I've been seeing a lot. Maybe that's a topic for next time we could talk about subject to
there's-
transactions.
So basically, the bottom line is number one, give CJ a call at JK Closings, and he's going to give you his contact information. And when is the next time you're doing a contract writing class?
Yeah, good question. So 954-779-5000, you can call or text. I'm not sure exactly when my next contract review course is. We'll have to set it up. Definitely sometime in November.
Yeah, and anything that you think that you should point out for us to let us know about, we've got all this buyer broker stuff going on. People are asking questions. Anything crazy that's come up recently? I know you did tell us about the one where the person made a mistake and the agent had to give their money. But anything else happened?
Yeah, there's
recently?
there's a lot of mistakes being made with all of the different forms. Really reach out and do your due diligence with your realtors because there are a lot of realtors that don't do education like you do, that don't do a lot of transactions. I think the biggest thing that people don't understand is that realtors go to real estate school and they don't learn everything
No, you
in
learn it
real
from
estate school.
experience.
You absolutely learn from experience. And so you want an agent that is experienced and not just experienced in general. If you're looking in a certain community and that agent works in that community, they're going to have more experience in that community and know how to close that transaction.
Right.
And that's very, very important.
So we're running out of time. Thank you so much. We have so much information for you. Catch us again next week where we'll be live at our 2-year anniversary. Laura Sanders, Making Money with Laura Sanders, 954-650-0827. Call me. Bye.